plaintiffs say that they're bringing an as-applied challenge, which would be a challenge to the statute as applied to them only. That's what an as-applied challenge is. But the circuit court held that the statute was unconstitutional with respect to every person charged with a felony.
The state argues that that's too broad, where your claim is an as-applied claim only as to your two clients.
It is not as applied only as to my clients. It is as applied as the person's charged with a felony but not convicted. That is an as-applied challenge as well. It's a violation of federal law for a person convicted of a misdemeanor crime of domestic violence to possess a firearm, or a person adjudicated a sufficient degree of mental incompetence to possess a firearm. This same statute would require the state police to revoke that person's FOID card. That, as applied to those scenarios and every other potential scenario other than merely being charged with a felony, the statute remains in full force and effect. There is a federal statute, 18 U.S.C. 922, in as in Nancy, I believe it's the exact quote, that prohibits persons charged but not convicted of felonies not from possessing firearms. They can keep the ones they've got while they're under indictment or information, but prevents them from acquiring new firearms while they're under charge. That is what this case is about.
The Supreme Court is clear that the Second Amendment covers possession of firearms for self-defense by those considered law-abiding and responsible and not dangerous. This does not cover the plaintiffs because while they were under this felony charge, they had conceded that there was probable cause that they recklessly endangered others with firearms. So that would sort of suggest that shows that their claim would fail at the first step. And so for those reasons, unless the court has any further questions, we again ask this court to reverse the circuit court's judgment.